So let's officially, formally start this new pioneering radio show type model in which we invite a guest client onto the podcast. This will probably be produced, folks, as a podcast, perhaps a video as well, but primarily a podcast. And I have great pleasure of inviting for this inaugural session Tony Coe, who is a client of ours, relating to a beautiful nutshell case, as far as I'm concerned, that throws up all sorts of interesting issues. And we're going to talk through that case over the next 30 minutes or so. I have the able assistance of Daria Siatkowska.
Hello.
To plug any legal holes that I've put my foot into. And I think we'll and I think, as by way of a taster, this is a case that's uncommon in that the client won costs against his opponent on the small claims track. So, Tony, do you want to just first update us as lawyers, because the whole point of this of our legal service is that you do it with our support. So we don't know what happened recently, and we only got your message just last week. Perhaps you'd let us know how everything went down.
Well, certainly, and it's lovely to see you both. You've helped me a lot over the past, I think, couple of years at least, by providing ad hoc legal services. And just by starting out, I want to just pay tribute to you for a very great piece of advice you gave to me, Alex, when I first consulted you in connection with a case that I had against a high street bank. And you may remember that, well, first of all, I came across your video about watching out for striking out applications. And that was, I'd been given a really bad bloody nose by one of the big tech firms because I sued them. And I didn't even know that was possible until I learned that lesson that they could apply to have the claim struck out before it gets assigned allocated to the small claims track. I just didn't have any idea that I was exposed to that cost risk, and I got hit with a £600 cost order against me. They sent along a very clever young barrister who ran rings around me. And then I came across, I
don't know why I'm laughing.
That's just terrible.
It wasn't funny.
But it's those sorts of things that what's the word? Tried in the fire of real life experience, isn't it? You must have learned a huge amount from that.
Well, I did. And then I came across your YouTube video about that very subject, and I thought, next time I have however clever I think I am, next time I have a claim to make, I'm going to run it by this guy. And I did that, and I sent off my draft particulars of claim against the bank in question. And you took a look at it, Alex, and you were kind enough to say it's great, but I think you've got a strong case. But I advise you to first of all send the draft of it to the bank. It will be referred to their legal department, and that will probably result in something good happening. And it did. Something very good. They settled in full, and I got more than I would have done if I'd sued. Because they dealt with it as though it was a complaint that would end up with the financial ombudsman, which, of course, the financial ombudsman, as you know, has powers to be able to award more than things like inconvenience.
Yeah, exactly.
That sort of thing. And they ended up giving me hundreds of pounds more. I mean, it was a claim that was worth, from memory, I think it was about £5,000. So I got all that, plus I got hundreds of pounds in additional costs, I suppose you'd put it that way. So that was fantastic, and I was then sold on court wingman service. So,
crikey, this feels like it's been set up, doesn't it?
No, well, it hasn't. It hasn't.
But he has not been paid for this.
I think that before we get on to the case which we're concerned today, that is such an interesting, challenging area when you are up against a big corporation, and they just process you, don't they? And the customer complaints department are just trained to say lots of lovely things, but you never, sad to say, that you never get it in front of anybody who's got an understanding of the case. And it gets extremely frustrating, such that you kind of feel no choice. You've got no choice to issue proceedings, and then you end up being faced with the strikeout application. But this is just the lesson, isn't it? With a big bank, you've got to find a way to get your matter to the legal department, to people who are actually going to apply their brains to the problem and look at it properly.
Yeah, and I've learned subsequently that, you saved me so much grief, because let's face it, if you do go down the court route, the courts are just such a mess. They're so under-resourced. They lose the paperwork. You have to keep sending it to them. I can't begin to tell you what a nightmare it is. So if you can, going that route that you suggested of sending in the draft first, it was just such a great thing to do, and just saved us so much time and trouble.
Yeah, because the customer services
thank you for
people. My pleasure. It's great to hear good news. It's also great to hear that I didn't realize that you'd been following the free materials and videos for 2 years and getting value out of them. But I think just on that bank point, a properly drafted particulars of claim, when it arrives on a complaint handler's desk, is going to take one look at it, and he's going to say, "Oh, better refer this to the legal department." I guess that's what happened, isn't it?
Yeah, and I think that they must have given a nudge saying, "You need to settle this." I'm sure that that's what happened.
Right, because it then went back to the complaints department, and then they're the ones who finally decided what they were going to pay you. Is that right? Or did you ever correspond with lawyers at the bank themselves?
They simply, as soon as straight after I did that, really, they were on to me, and they said, we'll settle this, and we're going to put money in your account for the inconvenience, hundreds of pounds. So it was, it's just a fantastic result. So great.
Good.
Not only, by the way, I do. You said your free material. I have actually bought your book as well. So good. That was since then, and I've got very great value out of it, I must say. So it does sound like this is set up, but it really isn't. So coming on, I've forgotten your question now.
No, I'm just going to outline the benefit of the audience, the simple facts of this case. This is really worth listening into, folks, because it's what I've been wanting to do for ages, is to have a client on the show, so that you can actually see the real life nuts and bolts. Because the problem is, so often people litigants in person get stuck with the law and what the law says and the rights and wrongs of their case, and they don't get a taste of what it's like to be in the aerial dogfight. And you really need to get that flavour of what it's like to be in a dogfight in order to properly, airline pilots or fighter pilots, I'm sure they go into simulations and such, don't they? Our book is like a simulated fighter pilot.
Or a boat in this matter.
Or a boat, yes. Which nicely segues, Daria. Thank you for your economy to the case in question, which is about a boat. I'll just summarize the facts, then you can plug in the gaps and bring us up to date. Because it was a few months ago now that Tony came to us. He has a boat, Tickety Boo it's called, isn't it? I think.
Yeah, that's correct.
And Alex loves boats.
Well, I grew up on a boat in the southeast because my father was a yachtsman.
Really? I've actually boated myself all my life. And when my wife and I decided that we were going to leave London, because we'd lived in London for like 40 years. And then COVID hit, of course. And we were one of the first of the huge queue of people who exited London. And we had two dreams. One was to buy a nice house in the country, and we were very fortunate in doing that just before it went crazy. And we also decided that we wanted to buy a narrowboat because I'd brought up our daughters with narrowboat holidays, and I'd had other boats, but I'd never had a narrowboat. Thought it'd be a nice thing to do. So bought a really nice narrowboat, but had to get it. I don't know if you're familiar with narrowboats. Both
no,
of you,
I'm not.
They have.
What's the purpose? So that they can go up canals, or what? Or what's the purpose of a narrowboat?
Well, as you will know, England has this. The UK has this network narrow canals. They're beautiful. I mean, they were they were built going back to the 1700s, and they're narrow, and so you need a narrowboat. It's a really unique way of seeing the UK. And you get to see beautiful countryside, and you get to stop at lovely pubs by the canal and so on. But the narrowboats are steel boats. They're long, narrow steel boats. They look they're sort of a little bit like a railway carriage, because railways, of course, came after the canal system. And now they've long gone past their days of the purpose that they were originally constructed for, which was to obviously move goods efficiently around the UK, and now they're just for leisure. They're for holidays, but they have this unique aspect to them that they're steel, and they have to be blacked, what's called blacked, every couple of years because to protect the steel from rusting. So what we had to do is we had to take it into a boatyard about a year after we bought her to have her blacked. Anyway, cut a very long story short, they damaged the boat. The employee that dealt with us,
there were scratches. Just to step in there were basically you left it with them for a period of time, and when you came back, there were scratch marks on the stern, the back of the boat. There was also some internal damage. We're looking at about £1,250 worth of damage. The client had no complaint about the servicing that was done, as I understand it, Tony. It was just simply that they'd done the service and they'd correctly raised an invoice of whatever it was, £2,000, £2,500, £3,000 odd. But the client's position, Tony's position was, well, I'll pay your invoice minus the cost of the damage, minus the £1,250.
Yeah, that's it. That's a good summary. And the most important thing was, before we left the boatyard in question, the employee, we showed the employee the damage. The employee agreed that it was happened as a result of the works they did, and said that he was going to make a deduction from the bill straight away in respect of the interior damage, and that he would arrange for their people to come and correct the exterior damage afterwards. Well, the owner found out about that and decided that he was going to overrule his employey.
Yeah, that's quite an interesting point. I hope you'll forgive me for interrupting. I read the papers this morning, but you actually had a chap who was presumably directly involved in supervising the work, and that's the chap that met you when you went to pick it up. That's the chap who acknowledged that the damage had been done whilst it was in their possession and control. Is that correct? Did he acknowledge that fact?
Yes, correct.
It's quite interesting reading the papers. I've got them here, folks. I might put up some redacted sections because, what I loved about this case is the tone of the correspondence from the boss, who decided to wade in, get aggressive, Interestingly, the supervisor, let's call him Sam for want of a better description, who was the one actually handling the business and admitted to the damage, mysteriously disappeared. He stopped working for the company for some reason. So yeah, anyway, carry on. I just wanted to clarify the role of this Sam character and how he was the one on the ground who's critical to the case.
Yes, that's right. So he we were about to pay the bill, because we're people who like to pay bills straight away, and I said to her, well, let's just make sure they are coming along to do this rectification. Just get confirmation of that. And as soon as we started to do that, well, first of all, the guy actually emailed to say yes, but we'll have to wait until COVID, until there's a gap in the COVID restrictions. Fair enough. But I just detected something in the way that he had responded that sounded like backpedaling. And so I wanted to get a bit more. I suggested that we get something a bit more concrete. As soon as we did that, we found out that he'd disappeared, he'd gone. First of all, they said he was sick, which was a lie. And then it turned out that they'd fired him. And it would appear that they'd fired him because he'd made the agreement with us to do the rectification. And then this boss.
But you never got to the bottom of that. Did you ever get to the bottom? Of whether he'd been fired for his in relation to this issue, or whether it was for some other reason?
Yes, I got to the bottom of it because it came out as the court proceedings, ground on I think it was the witness statement from the boss stated that that is exactly what had happened, that he'd been fired for this.
Right.
But it became what happened as soon as the boss decided that he was going to get involved. First of all, he wrote a long letter saying how professional he was and how that now I was going to face the big guns, as it were. But his correspondence actually became, as you say, really aggressive. I mean, he started calling us fraudsters, liars, canal sharks.
Canal shark?
It was really yeah. I've never been called a canal shark before. Actually, I've never been called a fraudster before. I'm
just going to read a bit of this. I've just got to, because this is after he's sort of taken over from Sam and he's wading in here. I'm writing to inform you that I will now personally be taking over from Sam in seeking to resolve this matter to our satisfaction. Sam feels he has gone as far as he can as general manager, blah, blah, whereas he has the hands-on technical knowledge, he does not have my professional background, where this dispute now needs to go. I am the owner and managing director of, and then there's a long paragraph about him being on the stock exchange and all sorts of other things. What's so interesting about this, folks, as a kind of a point to take away, is he lists a lot of, you have made a ridiculous claim for repainting the stern bulkhead. Finally, by way of general comment, we've never had anything like this happen before. Blah, 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 blah. It's an outrageous. Now, when you get a letter like this, it's like you smile very sweetly and you think, well, yeah, but what are you saying? Because you're taking quite a lot of ink here to strut. Fine, you can strut if you like, but let's just, deal with the issues, because it then concludes, with a demand. You will pay our invoice of $2,500. We will commence proceedings. There will be a court fee that you will have to pay, which is quite ironic. The words we'll come on to. Finally, I trust that you now see sense and will comply. And the thing is, this has come out of nowhere. And it's the big point about here is, and there's always an opportunity in life to plug. I mean, but there is an important section in Flying Sailor about what you should do pre-issue. And a lot of this case and the costs award that was made against the claimant ultimately is around the fact that this chap has decided to sort of, I don't know, fire the guy, take the thing by the scruff of the neck, and then pile in with a long, grandiose, confident. I'd love to meet this chap. He sounds like a character. I bet he's quite a character. But really and this is a good advert for lawyers, really, he's not focused on the real issues. He could have simply said, I'm not sure that we caused the damage, Mr. Coe. In fact, I have strong suspicions that maybe the damage was caused by you before the boat arrived at our marina. Nevertheless, I want to be reasonable about it, and I'd like to commission a report from a chap that I know before issuing to see whether or not this might be the cause. Now, if you were confronted with a letter like that, it starts to seem rather more reasonable and you might have resolved the whole thing without ever having issued proceedings. Because tell us what happened after the ball back on your side of the court, Tony. What happened after you got this letter?
Well, it really got progressively worse because he made a surprise visit with a member of his staff to our home marina, and through deception got the marina to let, saying, "Oh, we've got to do works to the boat," whatever. He got access to the boat and went on board, took photographs of the damage, which I'd already. When I was at the marina, I'd done a video anyway of the damage. So all that this did, in fact, was to provide great photographs of the damage that they'd caused. I don't know really what his thinking. I don't know what his thinking really was. But what he did, actually, interesting to your comment, Alex, is that he then sent all the photos to a friend of his who was supposedly a court expert, who wrote a report saying that it was, well, even though you hadn't inspected the boat, by the way, the expert, on the basis of the photographs, he thought that the damage had been done previously, that something to do with the history of the boat. But to my mind, first of all, we were at the stage we were at that point where you would need to ask the court for permission to appoint an expert anyway.
That comes a long way down the track.
Doesn't
it, Dara?
Yeah, it does.
We're doing that in a case at the moment. What's your views on the so far on the order of events? And because Daria's come in completely fresh to this case, do you have any initial observations?
Well, I probably would not have been as aggressive as this guy. So I think that's where obviously he's gone wrong. No, at the moment it's
his next step was to pretty much issue proceedings.
But that's not how it should have been, should it?
No, because just writing a long letter isn't
exactly.
You don't comply with the pre-action protocol just by a long letter. You comply with the pre-action protocol by concisely laying out your response to the claim, or
which
your
is
claim.
Something he hasn't done.
Yeah.
So that's probably where that was the first thing that he's done wrong. Which is quite substantial, because, as you said, had he gone around it the other way, it might have ended completely differently.
Yeah. You wrote back.
Well, another thing. Sorry to interrupt you, but it just popped into my mind. Another thing that he did was that he wrote to me after the unauthorized visit to the boat the next day, saying that he, and this is almost word for word, "I have absolutely no qualms about boarding your boat without authority because you're a fraudster."
Yeah.
And so that sort of language really, when we get to the end of this case, and we end up getting a cost order because of the claimant's unreasonable conduct, that sort of language that he used became quite important. in persuade, because as you know, both of you know, Alex and Dario, it's not easy to get an unreasonable cost order. It really isn't easy.
It isn't, no.
So you have to be very unreasonable. And I think his unreasonableness throughout this case was palpable from his communication style, which continued throughout the case.
Yes, he's writing long letters, long emails, which don't seem to be getting to the bottom of the issue.
Yeah, I remember reading, picking up on the tone that you're talking about, and I might be able to find it, I might not, but as a lawyer, when I'm seeing letters that are loaded with emotion, and particularly where someone is throwing around accusations of fraud, which hardly ever are made out. I don't think I've ever had a fraud, a successful. Well, I've never had a fraud case where there was evidence of fraud. Fraud is extremely difficult to prove, but it just sort of. A lawyer kind of licks his lips, I'm afraid, is what happens, because the lawyer knows that they've become decoupled from reality, and you're dealing with an opponent who's incapable of separating his emotions from the facts and the reality of the situation, and it's a bit of a, I mean. It is the game for lawyers to win their clients' cases. So it's a rather encouraging sign when you're faced with a client, And I remember talking to you about it as well. I remember reading that initial letter, and I could just see the nature of the character: big, bristling, confident management guy who actually hasn't quite got the perspicacity to see what's really going on, and is just a lot of swagger, and you could just see from the very beginning that if he continued in the way that he was likely to end up on the wrong end of a cost order, even on the small claims track. Just to relation to reasonable costs, do you remember what the CPR provision was? I think the conduct has to be unreasonable, but the case law says it has to be, really quite unreasonable.
Yes.
So now, just before, when he came and visited the boat and took the photographs, was that after he'd issued the claim, Tony, or before?
Yes, yeah, afterwards, yeah.
So it's
he pretty much issued straight away. I mean, he, was very shortly after he got involved, he issued proceedings.
Yeah, because we've got the claim form here, and I think this is now. A lot of what we're talking about today is not necessarily about the rights and wrongs of this case. That's not what we're focused on. We're focused on how to properly fly the Spitfire. You may have a strong case, but you've got to fly it properly. Who knows? Maybe Tony Coe is an actor of the first class, Laurence Olivier caliber, and has fooled a lot of us. But that's kind of rather incidental to the way that one has to, I'm afraid, in civil litigation, comply with the procedure. So we've got a particulars of claim here. Look at that section there, Dario. So it looks like a debt recovery claim. Now, he hasn't properly laid out his claim in pre-action correspondence and a formal letter of claim. There's just the grandstanding letter. And he's then just like, well, sue and be damned, which, as we all know in this day and age, post the Wolf changes, is not something that presses the courts. But most critically here is at the bottom of what is a very short paragraph in the particulars of claim box, folks. He hadn't even filled out the box on the second page, had he, Tony? The details of the claim.
No, there was a line there saying that he would serve fully detailed particulars of claim within 14 days.
Yep, I will provide the defendant with separate. This is a official court statement of case, and he's saying, I will provide the defendant with separate detailed particulars within 14 days after service of the claim form. If I was his lawyer, I'd have advised him, don't put that in, mate. Serve them if you want, but don't, hold yourself hostage to a promise that you've made in your statements of case.
To be fair, that is something that was probably completed using MCOL. And so this is just the box that you tick. So you either put the particulars in there, but you've got a little box to tick, at which point this little sentence is added at the bottom of your
that's
particulars.
Computer generated by the court system.
So Daria, you're so right. And I now see why you're alongside Alex there. You're so correct, because when we had the final hearing, I'd made a lot about that. In fact, when I came and consulted Alex with regard to what we do in this situation, because Alex and I had a very fruitful conversation about whether to put in a defense or not, or to pursue the full particulars. And we had a debate about that. But I didn't find out, and I made a lot of the fact that he hadn't ever done what he'd promised, even though I'd chased it several times, because I wanted to serve a responsive defense. I wanted to see the claim first, and that's what Alex was advising, really. But when I was arguing for an unreasonable cost order, one of the points I raised was this: the costs were increased by the fact. By the way, I did get your fees back, Alex.
Oh, that's good to hear.
Yes, so we can come to that perhaps a bit later. But I did get those fees back. But that was one of the things that one of my arguments was that he never did this, and this was a further example of unreasonableness. Aha, the judge said.
Oh, really?
And then she made Daria's point. She said, this is actually something that happens, and she knew that. She was right on top of that. So that didn't get me anywhere, that particular one. But I'm so glad that as a result of our conversation, Alex, I did decide to put in a full defense, even though I wasn't responding to a fully particularized claim, because I knew that we had a strong case. So it was you and I agreed that what we should do is to actually set out the story. The defense was so important because as well as I do, very often with these small claims, the judge doesn't even get time to read the papers. They go, don't they, straight away to what the claim says and what the defense says. That's that's how they, even though we'd served a full, paginated bundle, which of course the claimant was supposed to do but didn't. Even though we'd done that, it hadn't even arrived at her desk in time for the start of the hearing. So, but what she had read was the defense, and she immediately, came to conclusions that were, in our favor. Of course, it was helpful that the claimant hadn't complied with the court order, hadn't served a skeleton argument, hadn't prepared the paginated bundle. So that was all very helpful. But I think the defense was extremely important.
So that was because what you've got here is an M1 claim. Now that can stand as your claim, even though obviously in this case it's brief. He's just suing for an unpaid invoice. But you have this thing about he's going to provide full particulars of claim. I think that he hadn't properly particularized his claim in the pre-action correspondence, and he's not particularizing it now. And there was clearly an arguable defense at this point, if you look at the correspondence from you pre-issue, such that a court, I would imagine, is going to say, particulars of claim are important in this case, and the defendant needs to read them before filing and serving his defense. So you could see a court, this is why it was a touch and go, because the conventional lawyer's perspective might be, well, no, insist for the full particulars of claim to be served and only draft your defense then, because otherwise you're in danger of being ambushed, because you've showed what's in your defense and you can then do a particulars of claim afterwards. But I remember the different every case is different, folks, tailored to the facts of the case, because directions questionnaires had then been filed and served, and he had sent an attachment with his directions questionnaire, hadn't he, Tony? Which did actually lay out his case, even though it wasn't a technical particulars of claim. I think that's why we decided, but was that not why we, at least in part, decided that it would be worthwhile putting a defence in?
You know what? I'm not entirely sure about that. I don't remember it well enough to be able to say one way or the other.
It was a factor. I went through the papers this morning, you see, so I've got the benefit of with his direction. He's so funny, this character.
No, I'm thinking about Alex. I think sorry, it's beginning to come back to me a little bit, because we had the conversation about whether to file a defense. The thing that I was particularly worried about in that conversation, you may remember, is that if we didn't file a defense, courts being the way they are and so under-resourced, I'm absolutely pretty much certain that I would have had a judgment in default entered. I wanted to avoid that. The bit that you're talking about in relation to the directions questionnaire, you're quite right about that. But we were having a separate conversation later on in the case, which related to an order that the court had made, which obviously had been written without the benefit of a full set of papers. Do you remember that?
Did we decide then to do a defence before he filed all his evidence with his directions questionnaire and that expert's report?
Yes, we did. We had that conversation right at the beginning, because I was very concerned that I wanted to meet the deadline for entering the defence.
And I seem to recall that your defence was just simple and straightforward. It's like what damage is done. And I think we also made the sort of concession, didn't we, by saying, we're happy to accept the document is dumped on the court on us, even though it is, it's not what is done is improper, and even though an expert report is actually, you can only introduce it with the permission of the court and at the much later stage. So I wonder whether the judge, I don't suppose you got a read of this side of it, but whether she might have felt that the claimant, the defendant rather, here was being very reasonable and being cooperative in terms of what we're talking about now, helping the court as well as yourself to manage the claim efficiently.
Yes, I think it was very, very much the case. In fact, I remember your words at the time when you were advising making that concession that we would accept what we had as the claim. And you said that, well, the judge will love you for saying that. Do you remember saying? You did say that. And I think that's true. I think that the court could see that we were doing everything that we could to be reasonable in the conduct of the proceedings, and our opponent was doing everything he could to be uncooperative and to be aggressive and overbearing. And I think that was very, very important.
So just get us up to speed with the final sort of chapter of the story in the run up to trial since we were last involved with the case.
Yeah.
Now, just to be before you do, there's quite an important letter. I don't know whether I advised you to write it or not. I think we worked on this together. It's a letter of 21st of May, and it's to the court, and it's kind of dealing with all the things that we've been discussing, isn't it? And it's laying out, because the court, as you've rightly pointed out, thought that they hadn't got your directions questionnaires, I think, didn't they?
Correct.
And so you had to deal with that and explain that it had been sent, and I think even provide proof of delivery. and satisfy the court on that issue? Because otherwise you were afraid of getting in trouble with the court or being, struck out for not having complied with the court order in respect to the directions questionnaire.
Yes.
And then and then we know that the claimant took the unusual step of filing evidence with its directions questionnaire, including an.
That was your line. I remember that.
Oh, okay. So
that sounds good, does it?
Oh, that's a brilliant line. Yeah. So and that's folks. This is just such a big takeaway is. Don't be tempted to put in the kitchen sink at the beginning. At the beginning, it's just laying out the facts of your case, your story, your reply, not bombarding the court with loads of evidence. That comes at a later stage of proceedings. Even in a small claim, in a fast-track claim, you've actually got a disclosure and witness statement phase. But even in a small claim, you've got exchanging evidence 14 days before. That comes well after the statements of claim phase. We've also mentioned that the character Sam, how folks' directions questionnaires are all about preparing properly for trial. For example, how many witnesses and which witnesses you want. So was it your intention to call? I can't remember. Did we decide you were going to try and get Sam into the witness box?
No. Sam had written a letter completely distancing himself, well, really denying that he'd come to the agreement at all. So I wasn't going to do myself any favors by calling Sam. I was going to rely on the correspondence, because the correspondence made it very clear that he had made the concessions that we argued that he'd made. It was very difficult, actually, to see how they were arguing anything else. Because
I see what you mean. Because he actually emailed you to the effect that that they were liable. Is that right? Yeah.
In effect, yes. I mean, he was saying that he was confirming that they would come and that they'd made the concession in respect of the interior damage, and that they were coming to take care of the exterior damage. So there was no doubt about it. I mean, it's the only argument that I forget what you called him, the stockbroker guy had, the ex-stockbroker guy had, was that he had acted outside of his authority by reaching that agreement with us, which turned out to be a terrible argument.
Did he? Well, no. Let's get on to the trial in a moment. I just wanted to draw to everybody's attention that this letter was quite important because it was a cool-headed, and Tony as a client, is very cool-headed, even where his precious narrow boat is, being criminally damaged by, and he's been accused of being a liar and a fraudster. I mean, keeping a cool head is those circumstances, Tony, is excellent. Perhaps you were in the military or something. But it goes with being a sailor as well. You have to keep your cool head, don't you?
Yeah, true.
It's bloody expensive if you don't.
No, right. My father always taught me, he was a chartered surveyor, but my father always taught me when I was working with him, anything that you put in writing, always assume that one day it will be read by a judge. That was his lesson to me.
What was his career or background?
He's a chartered surveyor.
Oh, right. Okay. Yes, and here also you make the concession that we're not going to insist on a particular claim. This is a small claim. Great, and so that was that was the last time we had contact. Tell us a little bit about what then happened. The trial was just a couple of weeks ago, was it?
A bit more than that, I think. I think it might be a month ago. Over a month ago.
So what evidence was exchanged? Presumably evidence was exchanged, was it 14 days before the hearing?
Well, we did everything from our side that we needed to do. We were, there was an order as to what needed to happen before trial. We complied with that meticulously, even though one of the conditions was that the claimant had to produce a skeleton argument, and then we were supposed to produce a skeleton argument in response to that. He didn't ever produce his skeleton argument, and then he never produced a bundle. He was supposed to produce the paginated bundle, and he didn't do those things. So we, the way the order was made in unequivocal terms, I mean, big capital letters and underlining and all the rest of it, that if either the claimant didn't do their bit or defendant didn't do their bit, either side, either the claim or the defense, would be automatically struck.
So he didn't read that order? Our big swaggering boss didn't read that order?
We'll have to get him on a future podcast and ask him.
Yeah, I'd like to.
I don't know what was in his mind, because he was constantly writing letters about how clever he was, and how terrible we were, and how the court are definitely going to find in his favor, and here's your last chance, and that was going on. That was going on all the time. So I don't know why he would make these, absolutely fundamental omissions, but he didn't, and he didn't attend the hearing. So
really,
no. So
how interesting.
So even with all that, in our favor, because we had been pursuing the court, because we were saying, look, according to the order, it should have been struck out, but though they said the judge wants to go ahead, the judge has received correspondence and so on. So we were wondering what we were going to face. We expected to face, a very aggressive attack actually at the hearing, and we were ready for that. And actually, another thing I've taken from your materials as a student of court women is how important it is to have your paperwork in order. And what I would say, we've always been very good at paperwork, because that's my work involves a lot of paperwork, and we've always been very good at that. So, but when I sat down to prepare the cross-examination of the claimant, I realized just how strong it was. Only then, really, when I pulled all the documents together and the chronology together, that I realized how strong our case was. In fact, I said to the judge, I was really looking forward to this cross-examination. I feel deprived. She found that funny. But if you do have your paperwork in order, and I thoroughly recommend not only reading all your material, Alex, but I thoroughly recommend a chronology, because it really, really helps you to focus, get everything focused, and make sure that you put forward a coherent case. So we were ready, but
Just on that point. Just on that point. Because it's just because someone doesn't turn up at a trial, don't think you're going to win, because you have to understand that civil litigation is all done on the paperwork. There's a witness statement. Obviously, it won't have as much weight if the person isn't there to be cross-examined about it. But it's still an eminently winnable situation, even if you don't turn up at the case. Well, it's not eminently winnable, but it's not impossible. And also, I've noticed that we've had on the odd occasion had court orders inviting the parties to allow the judge to make an adjudication on the papers only. That's the court pressures has obviously been seen as a way of dealing with that problem.
Yeah, we had that invitation, and I didn't think it was smart to go along with that, only because the courts from what we've seen, the courts are just so under-resourced that unless you're there to hold their hands and take them through, everything and point them to the right documents and the right bits of those documents, they could easily just miss the most important parts.
Yeah.
So, but certainly the preparation didn't go to waste, because it was very important in making the case, because it was quite clear that the judge was leaning against the idea of making an unreasonable cost order, because that's kind of the default position, isn't it?
Yeah.
But because of all that preparation, I had in my mind what the key arguments were and the key things to point to. So
if you had to list them out, what would you say they were?
Well, I think the most important thing, obviously, is not complying with the court order, and therefore making us to do things like prepare paginated bundles and things like that. So not serving skeleton arguments and so on. But then really making very clear that the case itself was meritless. In fact, she made a point in her order in saying that the claim was without any merit whatsoever. Really? So yes, she actually made that order. She also referred to the accusations of fraud, and how these components had clearly increased the costs. And coming back to, said I had to, was forced into a situation where I had to take legal advice, because of this sort of constant onslaught. And that's why we got, we were able to recover the fees that we'd paid to you. Best money I've ever spent, Alex.
How much was it? How much did you pay for our services?
Oh, I'm going to guess it was £300 from memory.
Yeah,
that is a bargain. And you got it all back.
And you got it all back.
Oh my word!
Yeah.
Lawyers for
now
free.
It is gonna sound like a setup, isn't it?
Yeah.
He has not been bribed.
We'll have to do a case with the client where it's gone off the rails.
Yeah.
Yeah.
Have you got one of those yet, Dara? No?
I'm going to say no.
We've got some difficult clients, put it that way. They probably wouldn't want to appear on a podcast, would they?
Pass.
Anyway, sorry, Tony. So, yeah,
no problem.
But the merits of the case was important to her decision. That's interesting, because I wouldn't necessarily have thought that was always the case in that applying that rule.
She was very careful in the way she drafted her order, it was. In fact, I should send that to you. I think. Please. I think you should take a look at that. I will do that.
Maybe we know the judge.
Yeah.
Well, it could go in the next edition of a book.
Yes.
When you say order, do you mean order or judgment? Had she handed down? Have you had a written judgment from her, or was it just?
Yes. Yeah. Yes. I mean, it's an order stroke judgment, I suppose.
But she goes through the details of the case and weighs the merits and the pros and the cons. So it's a full judgment, is it?
I wouldn't say it's a full judgment, no. But what I would say is that it has nuggets in it that, as I said, making clear that the claim has no merit whatsoever is an important.
Is it like a preamble within the judgment where it said upon the judge finding X?
Yes, upon this, upon this, upon that, upon hearing, and so on and so forth.
Okay, that makes sense.
Exactly.
See that?
Yeah. Well, no, definitely get that to you. So, I think she did a very thorough job, it's interesting to me, though, one thing, contrasting the first case that we the one before I ever came to you where I got a cost order against me, and contrasting that against the difficulty of getting an unreasonable cost order. Because in the first case, the intention of Parliament, as I understand it, when sort of setting up the small claims track, was to give little people the chance to take on big corporations, for example, without facing massive cost consequences. But on the other hand, there is this loophole that if the other side, as a corporation, manages to get in fast enough a strikeout application, then you get hit with a cost order. So the contrast between those two things, that in itself is a deterrent is a demotivator for a small claimant. You see what I'm saying? If you weigh up those two things, they are in conflict.
Yeah.
So really, it would be a good idea. Why make it so difficult to get an unreasonable cost order when the courts are so under-resourced that they want to actually, deter people from behaving badly in court proceedings?
Well, I suppose the answer to that is by avoiding the issues in relation to cost, that simplifies the matter.
Speaking in the microphone.
Oh, sorry. That by avoiding issues surrounding cost. Remember, there is a completely separate sort of cost court that deals with these matters. So I suppose by avoiding the issue altogether, you are avoiding lawyers, which is said to prolong proceedings. And so in that sense, you're avoiding that issue altogether. I know what you're trying to say in that it should actually, when people see that it may actually happen, they will take things more seriously as opposed to, well, I'm ready to go into that witness box. I'll tell the judge what happens. I understand what you're saying in relation to that. But at the same time, I can see why you can look at it the other way as well, I think.
But what do you mean by the other way? Sorry. I'm being a bit dense here.
So you can look at it as, well, cost orders, the rules around the cost orders should be clearer, and they should be granted on the basis that may deter people from pursuing cases,
okay.
right?
The unreasonable cost should be more freely applied by judges.
Yes, but then on the flip side, you've got the issue at heart. By keeping the costs away, you're more likely to keep the lawyers away, which was, of course, the intention of creating, I suppose, this small claims track. And so you can go both ways with that, I think. I
guess the judges are worried about defeating the purpose of the small claims track by encouraging lawyers with judgments that are more generous towards people claiming unreasonable costs.
Because it is difficult to get them. I mean, we've had a case where a client was given a runaround by their opponent, didn't find out that the opponent actually paid, I think it was 2 days prior to the final trial. And there was a lot of work, and the work that you had to do, for example, doing the court bundle, even though you were the defendant, etc. That is the type of work that our client had to do, and yet he wasn't given the cost order in his favor. So
legal costs, of course, because you do get costs of expert and court fees back, obviously.
Yes, but nothing beyond that.
Yeah.
But I can see it going both ways. You can look at the issue, and I suppose it's a balancing exercise. And I suppose the balancing exercise is then sort of smoothed out by the judges, who are then prepared to make a decision when it reaches the unreasonableness level. And of course, what is considered unreasonable will depend on the very circumstances of the case. So you are leaving a gate for a cost order to be made by not making it so difficult so as to create small claims effectively for lawyers, because that creates a category within a category of small claims track.
Yeah, I understand what you're saying, but I think that, the where I got hit with a cost order, which was where we started right at the beginning of this podcast, I had no idea that potential even existed, that threat existed.
Strikeout issue, yeah.
No, and I think that conflicts with the intention of Parliament to make the small claims track accessible.
I agree. I suppose,
because you've got a Mars case that you've got to draft the pleadings for.
Yes.
We've got a case where someone was a bit rough-handled who had a disability for not wearing a mask during the corona. Now, small claim, low value, up against a big supermarket.
Yeah.
If he doesn't get, and he'd come to us having tried a couple of times to do his own particulars of claim. They weren't bad, actually.
No, I don't think they were.
And the judge had knocked him back twice. Fortunately, I don't think he had a cost order against him, had he?
No.
Fortunately, it's very rare. Usually, I think they weren't quite quick-witted, or they weren't fleet of foot, or the lawyers weren't, because the bank would have instantly filed a strikeout application with a fee that would have been a lot more than 600 quid. I think that's the figure you mentioned. You know, we see people come to us having been through the strikeout ringer with £1.5, £2,000 cost bills and a requirement that they file a complete, you know, an amended particulars of claim within 14 days.
But again, that's different, isn't it? Because banks will be prepared for that sort of litigation, whereas the shops are not.
Yeah, but the point is that the Mast case was still a complex drafting job for some, because pleading a case under the Equality Act for discrimination is not straightforward.
It takes at least a day.
And police prosecutions are like this. If you've got a problem with the police, it's very difficult to plead it without the lawyer's help. Financial mis-selling litigation, very difficult to plead the unfair relationships test without a lawyer's help. Public bodies. There are quite a lot of areas where, the heavyweight corporations can just wade in. What do they care? It's only a couple of grand of a lawyer's fee, and morally neutral, play the tactical game and the point I think you make, Tony, is that people just aren't aware. They go on to Google, how do I bring my own small claim? Don't worry, there are no small claim, there are no costs awarded.
Let's bang it off.
Yeah, right. Well, it takes a while for it to get allocated to a small claims track. Does anybody ever tell you that? It's not a small claims court, it's a small claims track. Before it's allocated, it is a claim.
Yeah.
And you get costs awarded against you if you're not careful, if you're on the wrong end of an unsuccessful strikeout application. Maybe they're looking at it. Maybe we should write to the Civil Procedure Rules Committee. That's the committee that routinely looks at these sorts of issues.
We could do. I've got a few questions for them as well, actually.
Because this happens a lot. Mind you, it would be bad for our business.
Yeah, it would. I wouldn't have come to you if I hadn't got that horrible cost order. Yeah.
So any final thoughts, Tony, about the experience itself, the emotional roller coaster ride? I don't suspect it was all that worrisome for you, because you have a little bit of experience. You know, were you just doing it all on your own?
Yes. Well, apart from you, of course, your help. Yes. What I would say is that, there is no profit in litigation. I mean, it's, the amount of time that you have to put into it, unless you're talking about a lot of money, north of 10 grand, I think, it's very heavy lifting. In this case, I would have been, in financial terms, in pure commercial terms, I would have been better off just putting this down to experience and writing him a check, regardless of the damage. That's my thought on it. But I couldn't, I emotionally couldn't do that. Someone had reached an agreement with me. I'm big on when people have reached agreements. I'm big on, that they should comply. I comply with agreements I reach, and I think other people should. And I wasn't willing to let it go. But in commercial terms, Alex and Daria, I would have been better off just, walking away from it, really.
Yeah.
That's
and can we just clarify, issue. Lawyers do not benefit from litigation either. If you count insurance and all the overheads, not of fat cats.
Yeah, it's quite running your own. Yeah,
there's quite a lot of work involved, even as a lawyer. What people don't notice is that the tremendous amount of work that lawyers do for clients as well, way outside what is being paid for often. I mean, I can say that from my experience. So yeah, definitely.
What I would say, Daria, is that I think this way of working, the ad hoc way, the service that you offer, is really good, because obviously, you as the client are going to know your case better, and and the lawyer has got to, if the lawyer is going to conduct the case, they're going to have to spend as much time as you learning about what the facts are and all, looking through all the documents and so on. That is a very expensive way to go, but your ad hoc service works very well, in my experience.
For reasonably low value claims, especially.
Yeah, it's because I was able to send you the documents. You're very fast at picking out the key points, and that's a very valuable aspect of it.
Well, thank you very much. I really appreciate you stepping forward and being on the show. It's just so helpful to us, Tony, to get a real live person who's been through the dogfight. So really, thank you very much for standing up and getting the word out.
Totally my pleasure.
He's a proper graduate now.
So just no, obviously just a few plugs. I don't know if you've got anything to plug, Tony, but perhaps you should set up a competing business. You've got more experience than I have now. You've just been through a small claims trial on your own. So here's Flying Solo, guys. This is the Bible on running your own claim. www.courtwingman.com is our website. Our YouTube channel it's Redwood Legal Information because of an anachronism. You can find it by Googling Redwood Legal Information. And of course, as Tony has described, he only had to pay £300 to get, and the book, which isn't cheap. It's about 40 quid, isn't it? 50 quid. I hope you bought the hardback. Does it sound
really buy if I say I don't actually know?
Well, actually, I'm not a fan of having lots of books on my shelves, so I did actually get the soft copy.
Excellent. Well, you write notes in it and stuff, can't you? And use it to prop open the door.
But still, that's a compliment. He got your book.
Yeah, no, quite. So, thank you once again, Tony. Thank you for joining us, Daria.
Thank you, Tony.
And
pleasure.
Do email us, folks, at hello@courtwingman.com if you've got any follow-up queries or suggestions for other topics or other vlogs. Cheers.
Bye.
Bye, everyone. Thank you.
Bye. Thank you.